objection was that the Special Task Force has no legal standing, there's no legal powers, and therefore there's no reason for me to participate. And I know that one or two witnesses in my case also refused to participate in that. Because it's not as if there are no agencies in Malaysia which have legal authority. So, for example, the police can ask you questions. I went voluntarily to the police when they called me. I was happy to be questioned by the police because they have legal force, legal powers. And then, of course, in a case that you could appoint the Royal Commission. They could have appointed a Royal Commission which has powers, legal powers. So that is my fundamental objection. But in my letter to the task force, my task force, there were two separate task forces. The task force looking at my book, I also mentioned in any event, I've got objections to some of the members of the panel because of natural justice, or they are below in status, you're not being judged by your peers. So that is a secondary point. Now coming to Dr. M, I don't know whether Dr. M received legal advice on the first point. I don't know. So he was focused on the second point. And he's got a absolutely strong case because the one person who was very much behind Malaysia's attempt to re-litigate the case against Singapore in the World Court was the former Attorney General. So let's go back. And I think it was during Prime Minister Badawi's time, I think, where we filed the case. So it's Malaysia against Singapore, and both countries agreed, and unfortunately we lost part of the case. Actually, people forget we won half the case, but we lost half the case. But that is where the matter rests, because as you know, the World Court cannot impose automatic jurisdiction over states. States must agree. So for example, now as Russia is invading Ukraine, that dispute cannot go to the World Court because Russia will not be there. So Malaysia and Singapore agree, but part of that agreement is that you only have one bite at the cherry. There's no question of an appeal or a review. There's no appeal from. So that is what happened. And so for Apandi to advise the government that there is a review, in my opinion, was wrong. And I think Dr. M was actually correct when he took the decision. And from what I understand, he asked the London QC, we appointed a London QC, a specialist, to argue the case in The Hague. And our barrister, to my knowledge, advised the Prime Minister, I wasn't there, it was before my time, advised to drop the case. So Dr. Mahathir is acting correctly by listening to legal advice, and then you can't expect the same man to come and sit in judgment over Dr. M. Totally unacceptable. And I support Dr. M here.